Good evening, distinguished guests, ladies and gentlemen. A gentle reminder before we start, please keep your mobile phones on silent mode throughout the course of the event. And a very good morning and warm welcome to the Asian International Arbitration Center, more commonly known as the AIAC. The AIAC is proud to host this fireside chat, Perspectives from the Bench and Bar on Arbitration in India and Malaysia in Kuala Lumpur, which will include discussions between judges and experienced practitioners on key issues in arbitration in the region from varied perspectives. With that said, on behalf of the AIAC, we are truly pleased and honored to be able to welcome and host all of you at this momentous event today. And we are especially honored to have with us the Honourable Court of Appeals judges, Honourable High Court judges, Yang Berbahagia Datuk Ahmad Teriruddin Muhammad Saleh, the Attorney General, Yang Berhormat Tuan M. Kulasegaran, the Deputy Law Minister, and Yang Berbahagia Dato Sri Khairul Zaimi bin Daud, the KP of Bayou as well, and the representatives from the Attorney General's chambers, as well as former Attorney Generals of Malaysia joining us here today. To begin the event, we would like to call upon the Director of the AIAC, Datuk Sundra Rajoo, on stage to deliver his opening remarks and to discuss the landscape of arbitration in Malaysia. Please welcome Datuk Sundra Rajoo.
Thank you very much, Right Honourable Justice Surya Kant, Yang Arif, Datuk Mary Lim, Yang Bahagia Tan Sri Cecil Abraham, Mr. Anil Xavier, and Ms. Iram Majid, Honourable Judges, Your Excellencies, distinguished guests, ladies and gentlemen, a very good evening and welcome to the Asian International Arbitration Center at Bangunan Sulaiman. It is a rare privilege to host not only one, but two esteemed judges from the highest echelons of our judiciaries. I extend my heartfelt gratitude to Justice Surya Kant, who's all the way from New Delhi. In fact, I was on a panel where he was moderating in New Delhi on the Uncitral conference, and it was quite an event because it was attended by the Uncitral Secretary General, including some ministers and all these things. I also thank Yang Bahagia Tan Sri Datuk Cecil Abraham, who is a AIAC Advisory Board member and one of our very few truly international arbitrators. He does both commercial arbitration, international commercial arbitration, and very rarely, in fact, I don't think so, we have anyone in Malaysia who does investment arbitrations. So I think, we are very pleased to have him. And then Mr. Anil Xavier, who's the president of the Indian Institute of Arbitration and Mediation, and also the chairman of APCAM, and Ms. Iram Majid, who's the director of the Indian Institute of Arbitration and Mediation, and also executive director of APCAM, and for agreeing to come to this event. And we organized it at very short notice, 2 weeks. And thank you so much for all of you for coming here. And we have an opportunity here to gain a very insight into the experiences, and I think more into the expertise of our esteemed speakers and panelists. Now I go to what I'm supposed to do. I'm supposed to speak about the landscape of arbitration in Malaysia. And I have to start with what Dato Mary actually did for us in 2005, which is the Arbitration Act 2005. In 2005, I remember 30th of December, the Parliament enacted the Uncitral Model Law into our law as the 2005 Arbitration Act. And it replaced an archaic 1952 Act, which was the English Act 1950. So, and I think more importantly, in one act, we incorporated the New York Convention, which is, it is a very important move at that time. So we had almost like an omnibus legislation doing that. I think it was quite rare at our time, but the only time I remember that was done was actually Bafia in Bank Negara. So the model law in Malaysia is quite interesting. It starts in 2005. And at that point of time, all arbitrations as of 6th of March 2005 have to be under the new act. And it is also very interesting. For the first time, we segregated the types of arbitration, international and domestic. And then also the act had an opt-in, opt-out provision with a domestic provision. That means one act, two regimes, domestic and international. So I think that became the important milestone in our landscape. And subsequently, the 2005 Act was amended twice. The first amendment was in 2011, and actually it was a small amendment. Small, I wouldn't say it's major. It dealt with areas of ambiguity and inconsistency, because in 6 years, we could find we had digital green, where does the thing start? But I think more importantly, we also had certain thing that suggests what is the intervention that is required by the court to do. And then I think most importantly, the amendments in 2011 was Section 8 to restrict or to actually support arbitration rather than have court intervention coming in. The amended Section 8 in 2011 was confined to situations which are specifically covered by the Act itself. So you cannot go beyond the Act. So that was quite interesting. So the application of the common law and inherent powers was actually clarified not to be allowed. So I think that was very important. Then there was amendment to Section 10, and then more of the stay provision to make it easier. In fact, it became a mandatory stay. I think that's what to say. And then admiralty provisions for the first time came in the Arbitration Act in 2011. And then we had Section 10(4), which brought in line with uncial model law that the curial powers of the High Court apply not only to Malaysian seated arbitrations, but also to foreign seated arbitrations. So it became consistent. And then one very important thing that happened was Section 11 also was amended to increase the powers of the courts to provide interim relief. And it was quite important. And then one interesting comparison, the 2005 Act had, in Section 30, a provision similar to the present Indian Arbitration and Conciliation Act 1996. In 2011, we amended that. It is actually quite interesting because if you go to PASL case, it is dealing with the situation where the arbitral tribunal must apply the substantive law of India if it's a domestic arbitration. In 2005 Act, we had a similar situation. We had to apply the domestic law of Malaysia. In domestic arbitration, we'd have to apply the law of Malaysia. So the amendment actually removed that provision to apply, there's no difference. International arbitration or domestic arbitration, you apply the law that is actually chosen by the parties, which is applicable. That's, I think, the main thing. But then 2018, major change. In 2018, Centre's name was changed from KLRCA to AIAC, from the Kuala Lumpur Regional Centre for Arbitration to the Asian International Arbitration. And then there were many amendments made in that time as regards to uh, um, emergency arbitrator, interim relief to be given by the arbitral tribunal, which was not as clear, and then confidentiality provisions. Then I'm going faster. Representation. You could choose any representation, but also at that time, we also made an amendment to the Legal Profession Act. There was that it allowed anybody from outside, any lawyer from outside, or anybody can represent a party in an arbitration. That is section 3A. And it was that allowed in the Act, and then the Legal Profession Act was also amended to allow unrestricted fly-in and fly-out where arbitration is concerned. So I think that these are the main amendments. And then I think the Admiralty provisions were improved further. And then we went on to then change section. Remember, we changed domestic arbitration to allow parties to follow the substantive law that the parties have chosen in their arbitration agreement. But in 2018, we amended it to follow the rules of law. So you could actually choose a different system altogether. So it was in line with the Model Law 2006 rules of law. So the main thing, the other thing in 2000, which was actually the reason why the amendments in 2018 came in, was actually to do with interest. Do you all remember the Far East case? Interest, pre-award interest. In fact, that was actually the catalyst that started the discussion for the amendments, and then it was used to actually do the full amendments. Pre-award interest, compound interest is allowed. And then I think that's one controversial thing, section 42 was removed. So there's still debate about it. So that debate is to be done at another time, not today. And then so now section 37 is the only recourse for both domestic and international arbitration, award setting aside. That is as far legislation is concerned. As far as institutions are concerned, AIAC remains the main institution because it has a default appointing authority where parties do not agree to the appointment of an arbitrator or arbitral tribunal. And then it also provides, as you see, the suite of services, and we have amended the rules. Now, the latest amendment to the rules is the 2023 rules. So we have the conventional rule. The conventional rule now incorporates the fast track rules for a certain threshold, and then also incorporates the ancestral arbitration rules, which has all the provisions from emergency arbitrator to summary disposal to all the provisions are up to date, the latest provisions. So the other thing that the landscape where rights-based arbitration, rights-based dispute resolution is concerned is, of course, SIPA, statutory adjudication. And that has become a very important part of our landscape. And then mediation is actually still moving. The government has announced they're going to amend the Mediation Act. There is also an announcement that they're going to set out a national mediation center to deal with certain kinds of disputes. And then I think the court is coming up with, we have court annexed mediation, which is very important. And I understand that it may move towards mandatory mediation for certain kinds of disputes. So it's very, very interesting the way things are changing in Malaysia. And then I think the most important thing is that over the years, I write on this, I found the judiciary very supportive in actually supporting alternate dispute resolution. In fact, I think we have a very supportive judiciary. It has helped us tremendously. I won't go through the cases. It is there to be read. And then I think we are now at the age. The real question for us is this. India and Malaysia is at a crossroads. We need to retain our own arbitrations. It must not go out, domestic arbitration. But the real issue we're all talking about is how are we going to attract international arbitration, where we want other people's dispute to come back here. So ladies and gentlemen, I hope I've summarized the landscape. Thank you so much.
Thank you, Datuk Sundra. We would now like to call upon Ms. Iram Majid, the Executive Director of APCAM, on stage to discuss the landscape of arbitration in India.
Selamat pagi. So thank you so much, Datuk Sundra Rajoo, for the kind invitation and organizing this event on a very short notice and giving me this opportunity for presenting this session before you. It is my great honor as an Executive Director of APCAM, that is Asia Pacific Center for Arbitration and Mediation, standing before this august audience and in the presence of esteemed panelist, Honourable Justice Surya, Judge Supreme Court of India, Honourable Justice Dato Lim, Judge Federal Court of Malaysia, Datuk Sundra Rajoo, Director AIAC, Dato Cecil Abraham, lawyer and arbitrator, and Mr. Anil Xavier, Chairman APCAM. In this fireside chat on the perspective of the bench and the bar on arbitration in India and Malaysia, I would like to give an overview on the landscape of an arbitration in India before we start the panel discussion. Arbitration was in existence for a very long time in India under its traditional dispute resolution mechanism through village elders giving decisions on dispute among people. It was given statutory recognition with the Arbitration Act 1940 and thereafter by the Arbitration and Conciliation Act 1996. In 1996, we are having domestic and international segment both. Now, if you look the recent trend and development of arbitration in India, I would like to highlight the legislative developments and judicial support. The trajectory of arbitration in India has undergone a transformative journey marked by the introduction of Arbitration and Conciliation Act 1996, which underwent a substantial amendment. Like your Malaysian Arbitration Act also undergone many amendments. Similarly, Indian Arbitration Act and Conciliation Act 1996, it was earlier 1940 Act, and then we have seen a history of amendments. So we substantially underwent the amendment in 2015. Before 2015, the 1996 Act was there. It was a conclusive act, but even then there was a lot of interference of the court in the tribunal's function. But now after 2015, it was hammered down. And as Datuk has rightly pointed out that we are the biggest exporter, either it is Malaysia or either India. I can say about India more that we are the biggest exporter of our dispute, but in different jurisdiction. How to retain that? So for this purpose only, we come up with the different amendments so that the dispute should retain within the jurisdiction. And if you see the history of jurisdiction, the history of this amendment 2015, it was a remarkable change. It created a history in the world of ADR or the arbitration, because many people now they are seeking towards the arbitration. Before that, it was not much preferred. Thereafter, we had 2019 amendment and followed by 2021 with an overarching goal of refining and strengthening the arbitration process within the country. But 2015, the major things which we adopted in the act was regarding the time limit. So we fixed the time limit under section 29A, whereby the entire proceedings needs to be completed within 12 months. Suppose the party wants to give that consent, then it can be extended further 6 months. But beyond that, you cannot go. And definitely, if the court wants, then the court interference will be there. If it is not completed, then if court permit, then it can be concluded or it can be extended even beyond 12 plus 6 months. And we also, for the sake of uniformity in the practice, we come up with the model fee schedule, that is schedule 4, and which whereby gives the similar or the uniform set of fee schedule. And we also come up with the 2 different schedules in 2015, which talks about the independence and neutrality of arbitrator, schedule 5 and schedule 7. And in 2019, we come up with a very unique amendment that talk about the time limit to completion of the pleading. It is not that on the time limit only for the entire arbitration, it's 12 months, but beyond that, we come up with the completion of pleading, that is 6 months time. And all these amendments are, the purpose of all these amendments are that we aim to align the arbitration law with the international standards, drawing inspiration from the UNCITRAL model law. The effort underscored India's dedication to develop arbitration in both domestic and global front. While the judiciary has been a driving force in shaping India's pro-arbitration landscape, legislative initiatives are also underway to address unforeseen challenges in the existing legal framework. So now, notably, on 14th of June 2023, the government has constituted a 15th member expert panel to recommend reform to the Arbitration Act. And the anticipation is that these reforms will further refine and enhance the arbitration-friendly environment. The government is also taking steps to constitute the Arbitration Council of India. In 2019, by way of this amendment, we come up with a body that is called the Arbitration Council of India. So this body is a statutory body under the Act to supervise and navigate the professional arbitration system in the country. Another notable development of the Bar Council of India's decision to permit foreign lawyers. This is a good news for all of you. So it's the foreign lawyers and the law firms to participate in international commercial arbitration in India. This decision not only fortifies our domestic arbitration mechanism, but also elevates India's presence in the stage, in the international stage. And in the recent legislative milestone, the Mediation Act has been enacted in India, and the advent of Mediation Act marks a paradigm shift, establishing mediation as an independent and accentuated legal mechanism, and the mediation will be replaced now in conciliation. So now the act which we have, 1996 Arbitration and Conciliation Act, will not be the same, because the mediation will replace this word this conciliation from the act. So now I would like to highlight some key judgments in India which has helped evolution of a pro-arbitration friendly ecosystem in India. So in this context, I would like to highlight the judgment regarding the stamping of arbitration agreement. The NN Global Mercantile case delivered a unanimous ruling asserting that the unstamped or insufficiently stamped arbitration agreement can be legally enforced. It underscored the imperative for the court to confine their scrutiny during the pre-reference stage solely to the existence of the arbitration agreement, signaling a pragmatic approach to the arbitration enforcement. Second case I would like to highlight is the legal validity of the third-party funding in arbitrations has acquired the clarity through the Delhi High Court case. The name of the case is Sales Agency versus SBS Holding. The court implicitly recognized the practice of third-party funding, emphasizing the role in ensuring access to justice. Importantly, it is called for the formulation of the regulation to instill transparency and disclosure regarding funding in arbitration, safeguarding the third-party funders from undue liabilities. And the third case also, it is a very notable case. It is discernible shift towards a more flexible approach was observed concerning regarding the foreign seated arbitration. In this case, it is the name of the case is PASL Wind Solution versus GE Power Conversation in India. The Supreme Court demonstrated a willingness to grant Indian parties the autonomy to choose a foreign seat for arbitration. This reflects that the growing receptivity with Indian courts toward recognizing and upholding the choice made by the parties involved in the Indian related contracts. Another case, the ambiguity surrounding the scope and applicability of the group of companies. This is a very recent case where the Supreme Court in the Cox and King Limited SA versus SAP India Private Limited, the court affirmed the non-signatory groups companies can in principle be bound by the arbitration agreement under the doctrine of group of companies, dispelling uncertainties and providing more defined framework for its application. So these were the judicial support for the arbitration. Now, I would like to say this is, if we have to build an ecosystem for the promotion of arbitration, the conferences, seminars, and discussions are not enough. We always talk how any country can become a hub of institution or hub of arbitration institution. This is just a discussion which happens always and end always in such kind of conferences. But if you have to build an ecosystem, judiciary, tribunals, and institutions, everything has to work together to build the ecosystem. So now I would like to highlight a little bit about the role of arbitral institutions in India. A significant proposal in reforming institutional arbitration practice in the formation of Arbitration Council of India. The primary objective includes establishing, maintaining professional standard for arbitration and ADR services, and also grading and accrediting the arbitral institution. So this body will be grading and providing accreditation to the institution. Why? Because the institution are very, very important and catalyst to work for the arbitration. So on the path of establishing itself as a global arbitration, the hub indispensable role of Indian arbitral institution cannot be ignored. The arbitral institutions serve as a cornerstone in shaping professional arbitration in India. So since I am from institutions, so I need to mention about the need for the institution to collaborate. So I'm from APCAM, so recognizing the need for the collaboration effort on the broader scale, the Asia Pacific Center for Arbitration and Mediation has emerged as a significant initiative and formed through collaborative endeavors of arbitration centers across Asia Pacific region. APCAM seeks to foster institutional arbitration practices transcending national borders. See, APCAM with centers in 8 countries include India, Malaysia, Australia, Hong Kong, Indonesia, Thailand, South Korea, and Nepal operate with a common set of meticulous crafted arbitration rules, uniform fee schedule, and most importantly, with the common roster of arbitrators accredited under the common system and the APCAM Code of Conduct and ethical standard for the arbitrators, which gives the much wanted credibility and acceptance for the international arbitrators, gaining acceptance for users and divergent jurisdiction. Now, the association of esteemed institutions like the Asia International Arbitration Center, that is AIAC, and Asian Institute of Alternative Dispute Resolution, that is AIADR, APCAM underscores the collaborative potential in shaping the future of alternative dispute resolution in Asia Pacific region. APCAM and its member organizations stand poised to elevate arbitration standard in the region and contribute significantly to the growth and development of the arbitration community. So overall evaluation of the current situation, we can safely conclude that India is a safe seat of arbitration, unlike the rumors that you may have heard about Indian seat. So India's appeal as an international arbitration seat is underpinned by several factors. The first, as a signatory to the New York Convention, India facilitates the global enforceability of arbitral award and for offering streamlined support compared to non-recognized seat. The amended Arbitration and Conciliation Act empower Indian courts to ensure interim orders, enhancing efficiency for both foreign and domestic arbitration. The use of English language in Indian courts minimize the language barriers, ensuring effective communication. Arbitration seated in India enforce a time limit for award pronouncement and expediting the process. The country boasts various institutions like APCAM, IAM, MCIA, and IIAC, fostering a conducive environment, expedited arbitration procedures, recognizing of emergency arbitral award, and incorporation of IBA rules for ensure efficiency, independency, and impartiality. Additionally, India's affordable legal cost similar to the English law, the allowance of foreign lawyers as a party representative make it as a cost-effective and accessible choice for international arbitrations. So I hope that this fireside chat discussion will bring a positive transformation in the arbitration practice. Collaboration between India and Malaysia help business in both the countries to have a deeper understanding about the benefit of doing business and resolving disputes among them in a more efficient manner. But in the end, I would like to say that we need to go beyond business. We are going beyond borders. We need to go beyond business and take some initiative beyond the business. So I'm ending it with the two questions to all of you: that how many women representation are there in arbitration? And secondly, what we are doing for differently abled people. These two questions on which I'm creating projects. One is already done, that the women this is in the name of World ADR women representation in ADR, either it is in mediation and arbitration. Second is what an ADR or the arbitration can do for the differently abled people. And for this, we need to collaborate. See, only one institution cannot bring change. We need to collaborate beyond borders and beyond business as well. Thank you so much.
Thank you, Ms. Iram. Distinguished guests, ladies and gentlemen, without further ado, we would like to call upon the Honourable Justice Surya Kant to give us an overview of arbitration in Asia.
Thank you very much, all of you, for inviting me to Malaysia and giving me the second opportunity to share my views and ideas yesterday, of course, on mediation, and today on arbitration. Honourable Justice Dato Mary Lim Thiam Suan, Honourable Judge, Federal Court of Malaysia, Honourable Judges from the Court of Appeal of Malaysia, Honourable High Court Judges of Kuala Lumpur, learned Attorney General of Malaysia, learned Deputy Minister, Datuk Professor Sundra Rajoo, associated with him in some of the events in Delhi last time, Tan Dato Mr. Ibrahim, Mr. Anil Xavier, Iram Majid, representing as head and senior executives of the Asia Pacific Center for Arbitration and Mediation Center, members of the Malaysian Bar, members of the legal fraternity, very distinguished guests, ladies and gentlemen, very good evening to all of you. It's a great pleasure for me to participate in this seminar on the perspectives from the bench and bar on arbitration with reference to India and Malaysia. But as I would say, I have been asked or directed that I should speak briefly about the perspective of arbitration in Asia. So I will try to touch upon very briefly about some other neighboring countries also, how the arbitration is progressing so well when we are raising very contemporary and very serious issues with regard to the progress and development of domestic or international arbitration in two jurisdictions with which we are directly concerned today. Well, very educative insight of the law of arbitration in Malaysia has been given by Datuk Sundra Rajoo, and I'm thankful to Iram also that she has given a beautiful presentation about the Indian arbitration law, which commenced way back in pre-independence era in 1940, and then followed by a new law in 1996. Of course, before that there were some amendments, and then in 1996 law there are subsequent amendments which she has also referred to. I will give those brief details of those amendments and the impact on the law of arbitration of those provisions very briefly. I know that the time constraints are there, but let's understand, when we are talking about the growth of arbitration in Asia, as I will try to touch upon, we are 48 countries in Asia with a population of 4.7 billion. The legal systems in these Asian countries are also at varied, with a mix of civil laws, common law, charity law, and there are some mixed systems also. So it is in this background that I will try to touch upon the Indian, Malaysian, Singapore, Hong Kong, and maybe if I get some chance to just point out the jurisdiction with reference to the unsettled model laws based arbitration system and pro arbitration judiciary, how it is working in these countries. And we have to see it in the context of the ease of doing business also, because that ultimate gain, it's not that we generate litigation and resolve it. It's eventually the ultimate goal is that how our economies improve and we get an ease of doing business. And if the dispute arises in that process, then we have an effective modicum to resolve all these things. Speaking on a general principle, I feel that in the Asian jurisdictions, it's crucial for development of international arbitration. Then what are the factors? I see 3-4 C's. One is the commitment to enforcement of foreign arbitral awards. Do we have that commitment or not? Second, I think that we need to create a conducive commercial environment. Third C, to my mind, is the cost effectiveness. These three factors for any jurisdiction will be quite crucial for the development and growth of arbitration. Now, in the context of India, when we talk, in that way, India can proudly say that it was among the only 6 Asian countries who signed the Geneva Convention, and India was also among the 10 original signatories to the New York Convention. But then ultimately, after the 1940 Act or 1996 Act, which Iram has already pointed out, let me slightly concentrate on the 3 amendments of 2015, 2019 and 2021. The 2019 and 2021 amendments in the Indian Arbitration Act have really been introduced for encouraging the institutional arbitration and of course for promoting India as a hub of the international commercial arbitration. These major changes include those relating to timely conclusion of the arbitration proceedings, minimizing the judicial intervention, and enforcement of the arbitral awards. In a way, I have been earlier also saying that when the legislature of a country becomes cognizant of the need of the hour and keep on making timely amendments in the law to update it to meet with the latest challenges, I call it as legislative activism. And in that way, I can say that the Indian Parliament has really addressed the issues which the arbitral jurisdictions are nowadays facing in different parts of the world. So therefore, on the 3 factors, that how to timely conclude the arbitral proceedings so that there is no time uncertainty. 2, that if you pass the award, it should not work as a fulcrum it should have a complete, it should be an enforceable decree of law. It should not be a brutum fulcrum, that a decree which is only on paper. So it should be enforceable in law. So therefore, the arbitration awards, how to enforce them, the law is now taking care. And the minimum intervention by judiciary, that's a message the legislature has also tried to give. But as probably Iram has also pointed out, I will just very briefly refer to some of the decisions which shows that the judicial consciousness of the Indian judiciary not to interfere or have minimum interference in the process of arbitration proceedings. I think the first salutary, one of the judgment which I feel that the Indian Supreme Court has given, that is in Vedanta, where in the context of the enforcement of the foreign arbitral awards, and that was a case where the Indian government challenged the award which was passed by an arbitral award where the Malaysia seated tribunal was there, and the Indian Supreme Court declined to interfere. And we said that irrespective of the seat of the arbitral tribunal, it's a foreign award, and therefore irrespective of, even if it doesn't satisfy the conditions of Section 48 of the Indian Arbitration Act, the award is enforceable. I think that's a very salutary message which goes to the international arbitration world. The judgment also ruled out that the power to set aside a foreign award was only with the court at the seat of arbitration, since primary jurisdiction exercised by the curial courts is at the seat of arbitration. I think that's a principle which need to be, which really safeguard, and maybe this is a principle which span different jurisdictions need to be evolved. PASL Iram has referred to. I think that's also one very salutary judgment, and which is very progressive view, where the parties consciously precluded India from arbitrating, and they decided to arbitrate in a foreign seat. And the Supreme Court said that irrespective of the fact that the parties to the arbitration are Indians, despite that such a clause in the arbitration agreement that was upheld. I think even in the case of domestic award, this kind of principles evolved by judiciary are quite welcome steps, I would say. And the court refused to interfere on the ground of that it violates the Indian public policy. The judgment very beautifully says the brooding and guiding spirit of arbitration. I think that principle is something very quite remarkable. All of you will be aware of that. The Amazon case is again a judgment which I always prefer to cite, where the Indian Supreme Court upheld the enforceability of an emergency arbitrators award under the Singapore International Arbitration Center rules. Normally, as you will see, of course, Mr. Rajoo has pointed out that now you have a provision for an emergency award and emergency arbitrators appointment, but Indian law doesn't have any such express provision. But notwithstanding that, the Indian Supreme Court, having seen that such a provision is there in the different jurisdictions under the Singapore rules, that has been upheld, and the arbitrators emergency award was duly acknowledged and recognized. There are series of judgments by Indian Supreme Court time and again pointing out that there will be a minimal judicial intervention as far as the arbitration awards are concerned. I think in that very conference where Mr. Rajoo was there, I also pointed out our judgment to which Chief Justice of India now, and I am also, we were there in the bench in the ONGC and APCAM matter. I also, when as three principles when I was initially talking, one of the principles which I normally highlight is the cost effectivity. You see, unless the arbitration proceedings have the cost effectivity consideration in mind, we will not be able to attract the litigating public towards arbitration. The timely conclusion is one, of course, one of the finest principle which encourage the arbitration. But the cost effectiveness is also a very important factor. And in APCAM, because in India there were issues with some of the arbitrators, the kind of fee they were charging, and in that case, as you know, under the Indian Arbitration Act, we have a fourth schedule, which the the lawmakers themselves have enacted, under which a fee structure is prescribed. So in APCAM, for the domestic arbitration, we have enforced saying that the arbitrators will be entitled to charge fee only as per the fourth schedule of our act. The idea was again the cost effectiveness. Let me just out of context give you one small example, and then you will appreciate that why this concern is there. I am from the bar, and when I was practicing in the High Court, I became Advocate General of the state, as you call Attorney General in some of the countries, and you call as Advocate General. And I was a very young firebrand lawyer, I would say. At the age of 37, I became the Advocate General of the state. When I took over charge of the litigation, the government, one of the case they put up before me was an international arbitration which was pending before the Singapore International Arbitration Center, in which my state's one of the corporate body was involved, and that was a state agency. So it was a case of huge financial burden on the state exchequer. So I found out that ultimately we have already spent millions of rupees, and the international arbitration was at the preliminary stage. So I was a bit worried, and the government was asking me to visit Singapore and to get it resolved. So I decided that instead of arbitration, let me go for mediation. I'm talking about in 2001. So I talked to, the dispute was with a German bank. So as an Advocate General of the state, I contacted the Attorney General of Germany, and through his good offices, I was able to reach the bank. I told the bank that, look here, I am ready to come to Frankfurt or Berlin, wherever you will say, but I want to settle this dispute. The bank chief managing director, he told me, Advocate General, you are welcome, we would like to settle the dispute. So the Council of Ministers authorized me, and they gave me full power that it's my discretion to settle the dispute. So I went to all the way to Berlin, and from Berlin then I went to Frankfurt, and I'm sharing with you, in 35 minutes I resolved the dispute. It took me 35 minutes only. I was carrying a checkbook with me. I was authorized by the Council of Ministers. So then and there I signed the check and gave to them that, look here, this is your amount and you please take it. I resolved the matter. So two factors please keep in mind. I'm not saying that mediation is more effective than arbitration. But what I'm pointing out that the cost of arbitration discouraged me to continue with the arbitration. So that is what one of the factors I would say. The other principles the Indian judiciary has really pointed out, when in group holding doctrine issue came up, we were in 3-judge bench. My view was I disagreed with the then Chief Justice of India, and I wrote a separate judgment saying that the group of companies holding need to be developed in our nation or in some of our jurisdictions. I had my own reasons, those are mentioned in the judgment. And the matter was ultimately referred to a larger bench, and eventually the larger bench has approved my view, and they have said that group of holding doctrine, this principle need to be evolved. The idea was that in some of the countries, particularly in India, the singular name entities really work. You may be known as Tata, you may be known as Ambani, you may be known as Adani, you may be known as Vedanta, you may be known as XYZ, you may be known as State Bank of India, you may be known as Life Insurance Corporation or any other thing. So sometimes all your subsidiaries, what they hold, how much assets they have, and ultimately a company or a stranger maybe comparatively who doesn't know about your internal working, he might enter into a agreement seeing your first name and because of your entity. And if you are actually a subsidiary and ultimately you want to wriggle out of your the arbitration liability or the award liability only by saying that I as subsidiary doesn't have any assets, sufficient assets to pay, that may not be that will not send a correct message to the international business community. If you want to attract the international investments in your country, and if you want to really do something for the upgradation of your economic growth, all these principles may be hard, may be harsh, then you have to ultimately accept as a part of your legal enforceability system. So those were the reasons that ultimately the Indian judiciary is going in that direction. those who are the loser in an arbitration proceedings. If you don't have any other ground, normally public policy and natural justice are the very common grounds. And that's very, very wise, I would say very mature judicial wisdom reflected in the in judgment of the Vincent, where the court clarified that public policy ought to be read narrowly and very restrictively in the context of an application which is moved to set aside an award. There the court also held that if the arbitral process is allowed to be compromised like this, then on a question of mistake of fact or mistake of law, then it will very, very difficult to sustain the awards. And the High Court of Malaysia also has in some of the judgments taken this kind of view. That simply shows that some of the amendments which Mr. Sundra Rajoo has pointed out, that also I would see that the Malaysian legislature is also cognizant of the fact that what kind of progressive laws you require to have, and so is the judiciary. So therefore, I think somewhere in the practicality of these laws, enforceability of these laws, creation of an environment for enforceability of these laws is something, those areas which need to be looked into. And maybe that, as Iram says, that the institutional arbitration may be one of the good answer. And in both the countries are now that you are running some successfully some of the institutions, to my mind, that can be a welcome step, and that can be something which the arbitration community, as I will use the word, is looking forward and eagerly looking towards you for those purposes. But then we have to see that how successfully in some of our neighboring countries are doing so well, pretty well, and what are the best practices there that maybe that we are lagging behind somewhere. And that element of mutual trust, faith in our system, that need to be invited, attracted, protected, and promoted. These 3-4 principles are to be kept in mind when we talk of, like in Singapore, I feel that the arbitration has really gone and achieved great heights. When Iram used the word that we are exporting arbitration, I think that clearly gives the message. I'm aware, I think in one of the my opening speech in maybe in one of the conferences in Delhi, only I pointed out that how much billion of rupees, or you call in the Singapore dollars, arbitration dispute India alone is prefers to get them resolved through the platform of the Singapore International Arbitration Center. And they voluntarily, so many the parties are choosing that. So therefore, Singapore, like India, has been a signatory to New York Convention, and it allows Singapore, of course, to enforce the awards that have been obtained in any of the countries that are the contracting state to the convention. That I think that's one of the progressive step, because wherever the award is passed, you can execute in Singapore. I must also point out that Singapore has very firmly secured its position as one of the most preferred seats in the world for international arbitration. And of course, the key institution is the Singapore International Arbitration Center. The scope of, again, judicial intervention in arbitration proceeding has again been in Singapore also very, very narrowly subscribed. The Singapore Court of Appeal in a judgment in CAG versus CAI has very categorically held that the judgment itself gives the data that in 20 years only in 20% applications to set aside arbitral awards have been allowed, 80% have been dismissed. That's a good ratio in terms of least interference by the judiciary in the arbitral awards. There one decision in China Machine, New Energy Corporation versus Jaguar Energy, that's one judgment really impresses, where the court has held that only in exceptional cases that the threshold for breach of natural justice will be found to have been crossed for the purpose of setting aside an arbitral award. I think that's a good, but in the threshold only, if you will find, otherwise if you don't suffer any prejudice during those proceedings on the ground of so-called violation of principle of natural justice, then the award will not be set aside. This is especially relevant since arbitral awards in Singapore are majorly challenged on the ground of breach of natural justice only. In Hong Kong also, I find that their arbitration ordinance is the prevailing law, and this is also based on principally upon the UNCITRAL model law. Hong Kong courts have a very strong track record of upholding the arbitral awards and respecting the limited grounds for setting aside as contained in the Hong Kong Arbitration Ordinance. This has vertebly contributed to Hong Kong's position again as one of the preferred seats for international arbitration. One of the judicial pronouncement which I'm impressed to read it is the judgment in AI versus LG2, where the High Court confirmed that a high threshold must be met before an arbitral award may be set aside. There the award was challenged on the ground that the tribunal provided insufficient or inadequate reasoning for its findings. So it was a kind of a non-speaking cryptic award. That was one of the ground taken. And of course, simultaneously the ground of that the law was misapplied and the objections raised by them were not duly considered and due process rights were denied. All these grounds were taken, but the court rejected those objections and held that the tribunal is obliged to elaborate on is not obliged to elaborate on every part of its reasoning. It's not necessary for an arbitral tribunal to give a very detailed, reasoned judgment on every aspect, and where the award is sufficiently speaks about the reasons in support of its conclusion, that would be sufficient for a court to take a view, not to interfere in that. I think in a very recent landmark judgment ruling also, the Hong Kong Court of Final Appeal in C versus D, that's also very interesting case. There the court have said that in holding that the preconditions to arbitrations as set out in multi-tier dispute resolution clauses are to be treated as matters concerning admissibility rather than jurisdiction. That's a very important distinction they have drawn. It is to be treated as only for admissibility, not on jurisdiction, and the court reinforced the pro-arbitration stance. That's also something which a pro-arbitration view, and the courts have said that you will not set aside the award merely because the party pleads the lack of jurisdiction, because that is one ground which normally it is taken, and therefore the court declined. I find that besides Singapore, Hong Kong, Malaysia and India, as we have talked about, even other Asian jurisdictions are also doing pretty well. It's only a question that we need to create an environment. The Japanese Commercial Arbitration Association, the Korean Commercial Arbitration Board, the Cambodia's National Commercial Arbitration Center, these are all doing good, but maybe that somewhere a joint coordination among all the institutions and having the minimum uniform standards and particularly a very simplified procedure, along with, I think, a transparent, duly notified list of expert arbitrators who are available from one jurisdiction to other. These are some of the issues which need to be coordinated among the institutions. And I believe if those concerted efforts are made, we can, all of us, I think, as compared to various other segments and parts of the world, we can really be the hub of the international arbitration at different sports. The growth of arbitration, I can say, in Asia is inevitable, as the region is witness to enormous economic growth. That itself is a very good, a very positive signal to attract and to make ourselves as hub of the arbitration. What need to be, as I would, at the cost of repetition, I'm saying, the cost effectiveness, UNCITRAL model law based arbitration systems, the ease of doing business, and pro-arbitration stance of the judiciary. I think these are some of the very, very effective factors and components which will really attract the foreign investors preferring Asian countries for conducting their arbitration. The role, as I said, played by the arbitral institution in Asian countries will be of significant value. I think it's a remarkable performance by them during COVID-19. all of us can really very thankfully recollect the performance during that hard times. The way these institutions have performed, that can be really a very positive example, and it can work very well. Uh, of course, as a representative of the judiciary, I would say that judiciary's role in maintaining the integrity, the salience and value of arbitration as an ADR mechanism cannot be stressed enough. It is only through the court's timely decisions on minimized interference, high threshold on setting aside of arbitral awards, and an overall pro-enforcement view on awards that ADR is able to flourish as an efficient, confidential, neutral, flexible, and cost-effective mode of dispute resolution. I strongly believe that with increasing technological advancements, which have initiated a discourse on potential use of artificial intelligence tools in arbitration proceedings for purpose of document review, predictive analysis, legal research, and case management, and the various other procedural facilities, there is also a need for the judiciary and arbitral tribunals to be cognizant of the key challenges posed by the technology. That also we need to be aware. These, when I talk about the challenges by the too much advanced technology sometime, these may include the ethical guidelines for use of AI, data security, the privacy concerns, and the lack of transparency and accountability on the part of artificial intelligence models. I think in due course of time, since all of you are aware of these things, you will be able to address all these issues quite effectively. There is also, I feel, a need to ensure greater gender diversity in arbitral tribunals, since diverse panels ensure inclusivity while also bringing a broader range of perspectives, life experiences, and dynamism, which would consequently enhance the quality and fairness of arbitral tribunals. I hope that all of us will work in tandem and will take the arbitration to its deserving heights where we are eagerly waiting to reach. I would only conclude by pointing out what the father of the nation in India, Mahatma Gandhi, said, and that's a quote, it's quite worth quoting, and he says, "Conflict is an inescapable consequence of any human interaction or relation. Peace is not the absence of conflict, but the ability to cope with it." Thank you very much. Thank you for giving this opportunity.
Thank you to the Honourable Justice Surya Kant for your insightful remarks. It has been our utmost privilege to have you here at the AIAC. We are now going to move on to the Fireside Chat, Perspectives from the Bench and Bar on Arbitration in India and Malaysia. Before we begin, I would like to briefly introduce our speakers for this evening. Justice Surya Kant was designated as a senior advocate in March of 2001. He has held the office of Advocate General Haryana until his elevation as a permanent judge to the Punjab and Haryana High Court on January 9th, 2004. He was nominated as a member of the governing body of the National Legal Services Authority for 2 consecutive terms until February 2011. Justice Surya Kant assumed charge of the office of the Chief Justice of the High Court of Himachal Pradesh and was later elevated as a judge of the Supreme Court of India in May 2019. Young Arif Dato Mary Lim has been admitted to Lincoln's Inn as a barrister at law. Before her elevation to the High Court of Malaya, where she sat in the new commercial court, her ladyship served in various capacities at the Attorney General's Chambers of Malaysia. These include Federal Counsel, Senior Assistant Parliamentary Draftsman, Legal Advisor to the State of Negeri Sembilan, Deputy Head of Civil Division, and Commissioner of Law Revision and Law Reform. Young Arif Dato Mary Lim was the first judge of the construction court in Kuala Lumpur until her ladyship's elevation to the Court of Appeal, and she is now a judge of the Federal Court of Malaysia. Tan Sri Dato Cecil Abraham is the senior partner at Cecil Abraham and Partners. His career at the Malaysian bar spans over 50 years, and he has appeared regularly before the Court of Appeal, the Federal Court, Special Court, and the Privy Council. He has over 300 reported decisions of note to his name and holds the distinction of having acted for the former Prime Minister of Singapore and several Prime Ministers of Malaysia. He is also regularly appointed as an arbitrator in domestic and international commercial arbitrations and is the only Malaysian to be continually appointed as an arbitrator in investment treaty disputes. Lastly, Mr. Anil Xavier has been a practicing lawyer since 1991. He has been involved in multi-party complex civil and commercial corporate mediations and arbitrations. He is an APCAM certified arbitrator, APCAM certified mediator, and an IMI certified mediator. He is currently the chairman of the APCAM and is also the chairman of the Accreditation Integration Committee of the Asian Mediation Association. With that, I would like to call upon Young Arif Dato Mary Lim to begin this session. And joining Young Arif Dato Mary Lim on stage, our honorable speakers.
Thank you very much. Good evening. I understand this segment, or perhaps even from much earlier, has been run on a hybrid basis. Hybrid because we've got friends and colleagues watching and listening to us all the way in India, quite apart from locally. This is the final segment where we're supposed to have a fireside chat. For the last hour or so, we've been quite fired up, I believe, watching, listening about the landscape in the two jurisdictions. You can see from the backdrop, I hope they've not removed it. When I came into this auditorium, I looked at the two domes and I had to look at it again to see which dome was ours and which wasn't. And I would believe that particularly sums up the whole intent of this fireside chat. Looking at these two landscapes, there are similarities and there are differences. I think it was quite aptly put by the director that we are at crossroads. We're looking at two economies which are so poised to rise. Unfortunately, we are at two quite different ends of the world's economy. India is at the 5th of the world's economy's ranking and hoping to rise, like China, now to the 3rd place. Where do you think Malaysia is? Well, the last I looked, it's somewhere at past 20. We're hoping to get at least into some decent rankings. Perhaps not in the major league, but at least a little bit more decent. But we are at crossroads. There are obvious similarities and there are obvious differences. The fireside chat, in fact, has actually started by Justice Surya Kant. He has already given quite a large overview of all the different areas or perspectives that we ought to cover in order to make sure we get to this crossroads and we know the right direction that we ought to take. And that if we, and when we take those journeys, we haven't compromised our friend. India compromising us, Malaysia compromising India, that we will bring and walk with each other hand in hand. What has not been introduced about our most eminent guest, Justice Surya Kant, is that when his lordship became the Advocate General, He was actually the youngest ever in India to be made Advocate General. So really, we are in the presence of a very esteemed member. So namaste and congratulations. And when we get to our real chat, and why do we call it fireside chat? I looked it up, and you know, in today's world, it's so easy to quite Google. Why the word fireside? Well, somebody has already set the fire, and the intent is to have a little chat about it. Informal, but structure. So why me? It's supposed to be the two countries. So how are we going to organize it? Well, we are host. So we've got our two guests, and we've got such an eminent representative from Malaysia, none other than Tan Sri Cecil himself, who has sat in so many roles, just shy of being a judge. And not because he is not in the least qualified, far from it, but he has better roles and challenges to meet. So how are we going to structure this? Well, I'm going to just lead in this little fireside chat. The only thing that's missing, I guess, is probably some cheese and something else. So we will cover 5 very broad topics. We've heard the discussion, some general overview about the 2 respective landscapes. We also heard the second part, which is about arbitral institutions, how important they are. We're now going to go into a little bit of informal questioning about how really these 3 gentlemen feel about what's been said in exchange or what's said out there. Then we want to touch about somebody else, the executive, who really plays a very important role in the development of any arbitral community in any part of the world. We've heard about India's establishment of a special committee. Let's visit that in a little bit more detail. And the fourth part, which we heard quite a bit about, is about the courts, the role of the courts. We will investigate that a little bit more. And through me, perhaps we'll ask a little bit more probing questions. You perhaps will be saying, well, Judge, you are asking the questions, but we want to know about the Malaysian judges. So perhaps that's where Tan Sri Cecil is going to tell all, and perhaps Justice Surya Kant would say what he really feels about the judgment, apart from what his lordship has said about press metal. And I think the other case was Master Mulia, which actually was a confirmation of a decision of mine at the Court of Appeal. Well, and then we will end the day on something his lordship touched about, and which I believe was brought up by Anil just now, about gender diversity, about our young arbitrators, what's in store for the rest of us. While we are in the first month of 2024, we need to know how the journey is going to look like. So I hope that sets about right the kind of structure we will follow in this little chat. We've heard Justice Surya Kant. We haven't heard Tan Sri Cecil. We haven't heard Anil yet. So who should we ask first? Of course, we must ask our guest first, isn't it? Let's first ask our guest. Justice Surya Kant, you talked about the landscape in India, commenting about the presentation, commenting about Datuk Sundra's landscape, describing about the landscape here in Malaysia. And you so helpfully described how our neighbors in this region has done. And I think you pointed out that we're about 48 countries in this whole area with about 4.76 billion, a billion, I thought it was trillion, but it's all right, safe, we're a billion population. When we look at, having looked at the rest, and we know where Singapore is, where some of the jurisdictions are, would Justice Surya Kant, would you like to now tell us, let's put India aside, which jurisdiction would you like to be, that you would like India to be, of those few jurisdictions that you've visited?
I think very interesting and a very deep thought based question by Honourable Judge. That what kind of the jurisdictions that in the context of Indian arbitration world that we should adopt from the neighboring countries. Well, I would say that the ideally, whether it is for India and even I would say even for Malaysia or for any other country also, that this is the high time that we really pick up the best practices available in different jurisdictions, and if you are able to have an amalgamation of those best practices, and as I said, the ultimate aim of the alternative dispute resolution mechanism, but particularly as an arbitration as one of the modicum, is to provide speedy, cost effective, definite, transparent, and business oriented and pro business adjudication of the disputes. So for that purpose, to my mind, we should think of picking up the best practices wherever in the jurisdictions are available, and maybe through the judicial process or through the legislative process. If we can make them mandatory, and eventually that becomes part of the substantive law or the substantive procedure for adjudication, I will ideally prefer that kind of situation, of course, in India as well.
Thank you very much for that answer. Diplomacy at its height. We will now turn to Mr. Anil Xavier. Mr. Anil Xavier, I'm sure you share his lordship's view. Or do you like to differ on a Tuesday afternoon?
No, probably I would agree in the sense, see, wherever there is a up, there is a down. So a country as vast as India and as a country as vast as Malaysia, see, we may not be as pro-arbitration friendly as some of the neighboring countries, but there is a potential for making it the best jurisdiction possible. So rather than being in the peak, I would prefer to be in a country where it's growing and where systems can be upgraded. So I would still prefer to be in India or to be in Malaysia to do the arbitration, because there is enormous scope of improvement, and the population and the size of the country is so big that we are not a city country. We are a huge country, both Malaysia and India. And with that jurisdiction and with that population and with that trained legal mind available, there is definitely in the future, we would be the best. Probably as Lordship Shrikant has said, we could regain the hub of arbitration in these jurisdictions. So I would prefer to be here.
Thank you very much. I love that answer. Tan Sri Cecil, we've saved almost the best for last, but this is only the first segment. Tan Sri, you have excelled in arbitration, quite apart from appearing in our courts periodically, and you continue to appear. I'm amazed after 50 years of practice, you're still at it. But you know, you've done the country so proud. The announcers, the AIAC, Datuk Sundra Rajoo, has talked about you being the sole rep at the investment treaty arbitrations. I think what has not been said is that not only have you appeared as counsel, you have also appeared as the arbitrator, and you have also been the chair in these kind of disputes. And I think that is the kind of honor that has not been recognized. And I hope the audience recognize and accept the fact, acknowledge the fact how much repute Tan Sri Cecil has brought and credit has brought to our country, Malaysia. Thank you very much, Tan Sri Cecil. But that is only an introduction to my question. You've heard the answers given by our friends. Would you, looking at all the jurisdictions, think that Malaysia's arbitration has evolved enough, or would you echo the views of our two guests? Mike.
I think Malaysia is evolving as a seat for international arbitration, but I think we can do very much more. And the reason I say this is, as I look at our neighbor, Singapore, it's a city-state, and it has become, in fact, I would say the leading arbitral seat today. It's overtaken London, it's overtaken Switzerland, and the reason is we have to ask ourselves why. Firstly, they have a arbitration center which is extremely well run. They have administrators of integrity, very good and competent staff. They have very up-to-date rules, and they seem to have a procedure for appointing very competent and impartial arbitrators. So there are many things that we can do to replicate. There's also tremendous amount of support by the Singapore government. And I think similarly in Malaysia, we need more support from our government for arbitration. Arbitration perhaps is not very high on our list of priorities as far as the government is concerned. And the other thing, if you notice in Singapore, is if there is a decision of the Singapore courts which is not friendly, the Singapore legislature immediately makes the appropriate amendments to their legislation. We should also do that sort of thing so that if a decision is outrageous, it should then be set aside by legislation if necessary. So I think what we have to do in Malaysia is that, we have an excellent arbitration center in the AIAC. Our facilities are good. It's cheaper to arbitrate in Malaysia. So we should take steps. Maybe we should open our markets to foreign lawyers like Singapore does. And these are things which would greatly make Malaysia a seat. And then so far as our judiciary is concerned, we have a very friendly judiciary with minimal interference. And if we look at our statistics, I think Mr. Justice Lee Swee Seng recently dealt with a number of statistics. I don't have the exact figures, but they're very minimal. And it's almost impossible these days to set aside an arbitral award in this country. So I think these are things that augur well for Malaysia as a seat, but we still have a lot to learn from Singapore, Hong Kong, and perhaps other jurisdictions. I'm sorry to say that whether there are things that we can learn from India, I think there are some things we can learn from India, but I'm not so sure that we'll go all the way as far as India is concerned.
Thank you very much, Tan Sri. I'm going to stick with you, Tan Sri, because I want to move to the second part of our chat. You have talked about the judiciary, but you also touch on the institutions. But here I want to pin you down on, you say that we have a very robust institution here. We have heard Justice Surya Kant talk about certain key elements that must be present in order for the hub here to be a preferred seat. But can I pin you down to name, in your opinion, just three key elements that must exist in any institution above all other elements in order that our arbitral institutions can really excel? Three. If you have to find three, would you offer us those, please?
Well, I think the arbitral institution should be perceived as an independent organization, which is separate and independent, say, from government interference. That's, I think, the first thing. Then we should have to have administrators of integrity, and we need very competent staff. Thirdly, I would think we should have arbitration rules which are comparable with the best arbitration rules of leading arbitration institutions, and we have to amend them if they become inadequate. And then lastly, I would think we should have an inbuilt procedure for appointing competent, impartial, diverse arbitrators. I think those would be the considerations.
Thank you very much. I take those three, the last being part and parcel of that whole reactive body of rules to accommodate whatever are the most prevalent conditions. Justice Surya Kant, I mean, you've been talking about speedy, cost-effective, and you also touched on gender diversity. Would the three elements, key elements identified by Cecil be ones that you share, or would your lordship differ?
Well, I think what Mr. Abraham says is perfectly correct. These are definitely very important factors for promoting the institutional arbitration and popularizing the arbitration as in modicum. Having said that, I will again repeat that part also, that we as the arbitration institutions also look into two more important factors, is the competence and cost effectiveness. Competence of arbitrators is also a very, very important factor to my mind. We have the best of the infrastructure we may have. We have very competent staff also, very good building, very good environment. But unless the net product which we want to sell out from that showroom, unless that product is also of high quality and of great integrity, maybe that very high stake business disputes we may not be able to attack. So for that purposes, the integrity part, competence part, along with cost effectiveness, and what Mr. Abraham says, I think that can be an ideal combination of a successful arbitration setup.
Thank you. Mr. Anil, Xavier, you ran these kind of centers, you run this kind of centers. What are your three top key factors that you must meet every time?
No, actually, all institutions, I would probably think that Datuk Sundra Rajoo is also facing the same situation, because when we are making arbitration more effective, we are making the outputs of the arbitration, like the arbitral award, to be less interfered by courts. See, the clients are always facing a major question, because in arbitration, they are entering into a room which doesn't have an exit, because it only exits by an award. And if the award is becoming almost impossible for a setting aside or not interference by court, see, the crucial person who is going to administer justice is the arbitrator. And unless and until the arbitrator is beyond doubt and absolutely credible, especially in a foreign jurisdiction. Of course, domestic jurisdictions also have the same issue, but especially in a cross-border arbitration, when you're going into a different jurisdiction and you're going to get an arbitrator from a different jurisdiction, and we do not know how that arbitrator will behave or how that arbitrator will be effective in the resolution. And the outcome, as we see day and day, or when we progress, the courts are very limitedly interfering with awards, and it is going to be the final decision of the arbitrator. So the code of conduct of the arbitrator, the accreditation standards of the arbitrator, the effective rules built in within this institution, where if the parties have a genuine grievance against the arbitrator, how the arbitrator can be replaced, how the arbitrator follows the ethical norms and the code of conduct. See, these are the major considerations that we always face when a client approaches the institution. More than the procedure of arbitration, how credible is the arbitrator, and how credible is the accreditation of that arbitrator, and how effective and how neutral, and how he gives equality and fair procedural justice to the parties. This is the most vital consideration every user takes up when they come for an arbitration, because I think if we can guarantee a good arbitrator, then the process can always be modulated by the rules of the institution, and there is no problem in that. And now, in fact, in APCAM, we are introducing artificial intelligence to minimize the human errors that the arbitrator can commit on procedures. But ultimately, the reasoning, the decision is on the arbitrator. And in fact, during the speech of Justice Surya, he was mentioning about various decisions of various jurisdictions where even if the reasoning is not elaborate, if there is a reason, there should not be interfered. So that again gives a jitters to our institutions, because then we have to make sure that the arbitrator is so perfect. Otherwise, see, 5 failures in arbitration will end up in people losing interest in arbitration. So that's I think the credibility, the code of conduct, the accreditation standards of arbitrator, I will put that as the topmost priority. Then, of course, the flexibility of the rules of procedure given by the institutions for various innovative mechanisms.
Thank you very much. I really welcome that answer. But then can I follow up with that topmost priority, that the quality of and competence of your arbitrators are so quintessential to the whole process? The question that naturally arises is the matter of discipline. How integral is it that if there are failures or non-compliance of these standards, the necessity or the need or the presence of sanctions against these perhaps classified as wayward arbitrators, over the question of independence and therefore impartiality? We've very frequently heard that you have arbitrators and you've got arbitrators, and no person really needs to write exactly in the same way. And as Justice Surya Kant said, that so long as you have some reasons, that's the award. That's the kind of choice that you have made. So now, on the one hand, you've got your AI to try and come out with a near perfect award with almost zero error, but you're dealing with a human being. And in the event this arbitrator falls short, the need to sanction, and in sanctioning, would you be compromising independence on the part of the arbitrators and protecting them at the same time? Your views?
So in fact, under the APCAM Code of Conduct and the accreditation system, we have recently started the feedback from the lawyers and the parties who have participated in arbitration about how the arbitrator conducted himself and how he was giving them the neutrality and the freedom to participate, and all this procedural aspect. We get the feedback from the parties and the lawyers, and in fact, all the arbitrators, when they empanel, they have agreed to that system. And we are making a feedback digest of the arbitrators, so that in future, how the parties select based on the recommendation of the earlier participants in arbitration also is a key element. And if there are some negative feedbacks that are coming to an arbitrator, there is no, the first sanction is not there, but there will be a friendly letter sent to the arbitrator saying that there is a negative feedback on this aspect. Is there any possibility of maybe on a particular case that has happened, but what would be the reply of the arbitrator? So we in the APCAM system, we have introduced something called the reviewer system, where if the arbitrator replies and it's satisfactory, then there is no further follow-up. But if the same type of feedback, negative feedback, comes in a next case or a follow-up case, then the arbitrator will be told that he'll be kept on hold for a period, and he will not be appointed as an arbitrator for a time being. And and he will be taken off from the international panel and it will be confined to domestic panel. There will be some little bit of sanctions that will be made, and of course the arbitrators are not happy with that system, but we have to do something because ultimately arbitration is as good as the arbitrator.
I will touch on something that is very close to a lot of people's hearts, their pocket. Would there be a deduction in their fees as a result of a little bit of improper conduct here?
In fact, we had put that in the first rules, but our committee thought it is not proper to reduce the fee because in one case, because of a negative feedback, it's improper to do it. But of course, the suspension part, we are keeping it.
Thank you very much. I want to move now to the final bit when dealing with the role of arbitral institutions, and that's third-party funding. We heard the response of India that third-party funding is very intricate and part and parcel of access to justice. Justice Surya Kant, the development of law in India recognizes third-party funding, particularly for international arbitrations. Would you like to elaborate a little bit more about it?
First of all, I think we will proceed on the premise that the third-party funding is an evolving concept. I think it's not a kind of a well-established notion as so far, and it's a newly evolving concept. And the entire this concept is developing on the premise of mitigating the financial burden on the parties who are engaged in a very complex or maybe a very costly international arbitration. There can be, say for example, on one side there can be mighty state or the mighty state agencies, and the other side may be a private entity not in a position to engage the kind of team to counter the battery of legal jurist or the legal team with engaged by the other side, and may not be able to bear the cost part of the arbitration proceedings. In that case, all right, the third party come and third party funding offers a solution to provide necessary capital by the third party to cover the kind of litigation expenses in arbitration. Definitely the advantage of third party funding, as we called it TPF, is because it's a case of risk mitigation. When there is a third party funding, of course you transfer the risk to the third party who takes over, and India, to be frank, it's not that first time it's happening. We have another statute, very again a very that's a commercial statute that we called the Surface Act. Under that we have statutory recognition of the credit institutions when they create the corporate entities who take over the loan liability on their behalf against the borrower, and it is they who go for recovery of the dues, and there is there is an element of risk, of course, involved for those parties, but then it's a kind of where the loan amount is sold to those entities, and the due amount, and they bargain with the financial institutions and go against the borrower, against the debtor, and then it is they who indulge in the entire litigation. But that is one where officially it is taken over by that third party entity. Now under the arbitration, when the third party funding concept is developing, there it is kind of an unofficial. The litigating party is only those who are party to the arbitration agreement. The third party only comes and fund and takes the financial mitigation of one of the parties. Delhi High Court has, as Iram has referred to in tomorrow's sale agency case, they have acknowledged. To be very frank, up till now there is no decision by the Supreme Court of India, and it may be A.K. Balaji was there. It is referred. it is referred there. So that's exactly I'm coming to that point. In Supreme Court, the issue is as of now sub judice. Maybe that I will not be able to give a very definite opinion about it because the matter might come. But having said that, I feel this is a very interesting, but as of now a debatable area where there are pros and cons. Maybe eventually it may lead to help a party who is being made to suffer injustice because of the financial constraint. It may help that party, but at the same time, I am wondering that it may not lead to a kind of an exploitation of that very party by a very robust or financially sound entity in the name of third party funding. All these issues I think need to be debated, and we have to really very objectively consider and find out some via media for it, that how and to what extent this kind of practices can be successfully allowed to prevail.
Thank you very much. Tan Sri Cecil, AIAC, I understand, accepts that or recognizes that there may be third-party funding in some of the arbitrations, but there is a need to declare it. Do you think that's doing enough? And very often, I mean, this question, as far as I know, hasn't arisen in any of the court challenges at all. But in your view, should we, in the name of access to justice and recognizing that there may be exploitations, nevertheless, accept the fact that arbitration is so expensive, there is a need to have some funding, third parties, though it may be. Your views, please, Tan Sri.
I mean, I believe that Malaysia should legislate and make third-party funding legal as has been done in Singapore and in Hong Kong, because this will then, and this will mean that there is access to justice insofar as claimants are concerned. In the area of investment treaty arbitration,
You need to bring the mic closer
a
to you.
great deal of the investors who bring claims against governments are third-party funded as such. Now, there may be a reluctance in Malaysia for third-party funding because the Malaysian government has been a victim of third-party funding in the Sulu arbitration. But that is not the reason why we should not amend our Arbitration Act to make provision for third-party funding. But what is important is, if there is third-party funding, there should be disclosure made so that maybe the respondent may want to take out an application for security for costs. As such, in fact, in one investment treaty arbitration case in which I sat, there was such an application, and we did grant security for costs against a third-party funder. It didn't go down too well with a third-party funder. So we need to amend our laws because we have maintenance and chapitry. So those laws will have to be outmoded anyway. They should be done away with. In addition to third-party funding, I think what we should also do, we don't recognize in Malaysia contingency fees, save in personal injury cases. There's no reason why we shouldn't have conditional fee arrangements for arbitration as such. So I think these are steps that we need to take if we want to encourage foreign arbitrations to come to Malaysia, and so that Malaysia can be a seat, because they can then say, well, third-party funding is permitted. Now, coming back to Rule 11, Rule 12 of the AIAC rules, we have that provision, and it says you must make a disclosure. But I think the situation may well arise if a party is third-party funded in respect of a Malaysian seat subject to Malaysian law. Well, some clever lawyer is going to take the point that this is a champertress agreement, It is against section, it's against the Legal Profession Act and so forth, and challenge the third-party funding. So I think for that reason, it is imperative we amend our laws. I think that if I'm not mistaken, a proposal was made some time ago to the government to amend the laws, but we got the feeling that the feedback was they were not very perceptive to that.
Thank you very much. I recall that the third-party funding was on the cards together with a whole bunch of others. Perhaps it was put on hold rather than rejected. And I like the positive recommendations from your good self that it's a holistic approach that needs to be adopted. If you might as well deal with the devil in front of you than have to fight shadows. I move then to the next. There isn't really much time for interventions from the floor. Perhaps we could keep that to the end if time permits, if that's fine by all your good selves. So I want to now deal with a very important element in arbitration, why some jurisdictions succeed and some jurisdictions succeed better, and that's the role of the executive. We heard just now about how in India, an expert committee of 15, I understand, has been appointed since as far back as 2019 to oversee reforms to the Indian Arbitration Act. I suspect, and I'm going to guess here, Justice Surya Kant, that part of the reason is because it's a realization that India is poised to take a better position in the in its economic performance. But it is not just only in terms of the economy. I'm sure it's for more reasons. Would you attribute that to be the only reason, that it's because you want to see more arbitration jurisprudence in India to make India a safer seat, or are there more reasons for the executive to play a greater role here in promoting arbitration?
Thank you. I think that's very important issue the Honourable Judge has pointed out. Well, growing economy of any country has definitely direct nexus with the growth of the arbitration or any other alternative dispute resolution mechanism. In the context of India, and maybe various other jurisdictions, we can point out that in the Commonwealth conventional system, adversarial system of litigation as we have, the civil courts definitely take some time in adjudicating a dispute. We have, of course, alternatively established the commercial courts under the Commercial Courts Act of 2015. Those are also very speedy mode of dispute resolution. But as I said, arbitration is something which the foreign investors normally in their agreement, in their bilateral or tripartite or whatever may be the enforceable documents, they go the arbitration as one of the most preferred mode of dispute resolution. And therefore, growing economy, it has a direct nexus. But then, in addition to the economic growth of a nation, I firmly believe that how are you rated in enforcement of rule of law, the value of democracy, the constitutionalism, I think all these factors are also extremely important. And these two also, unless the nation, the country as a whole, create an atmosphere and send a message to the international community that here is a country where the rule of law is duly respected, and you have an equality before law for each and everyone. And even if you are not a citizen of the country, you have so many rights which you can forcefully enforce under the existing legal system. And you have along with rule of law, you have an independent judiciary in the country. I think these are also the very important factors which along with the growing economy will matter a lot in in promoting arbitration, in promoting alternative dispute resolutions, and of course in inviting the international or the investments and the rise of the business or startups in your country. That these all factors will have a combined effect. Then only probably you can have a successful story.
Thank you. Anil, Mr. Anil, would you see the government in India doing enough for the institutions as it is? There are so many institutions in India looking after arbitration and conciliation, now looking after arbitration and mediation, and then we've got them in so many states. From your own experience, is how crucial is the role of the executive in promoting, in supporting the development and the growth, and whether or not this establishment of so many centers in India is the correct way to go?
No, I would say that the amendments that the government brought in, and even the new committee that was referred to earlier. See, the idea of the government was to attract India as a seat of arbitration and to reduce court interference. Because if you look at the notification on which the 15-member committee was formed, the notification specifically mentioned to come out with ideas for reducing court interference. But it's a catch-22 situation where if you take away the powers of the court in interfering with awards, you're actually putting up a wild house in open, because then we do not know in what manner entire arbitration regime proceeds. But the government now, the law ministry is also taking steps to make an arbitration law by which adequate autonomy is given to institutions to navigate the arbitration process in accordance with the rules that they make, so that they become competitive and give more options of autonomy and more options of choosing what type of mechanisms you need to complete the arbitration process. And moreover, now the present trend of making hybrid approaches like MEDAB or AMEDAB, or even hybrid hearings, all these could be navigated not by an act, but by the rules of the institution, which the parties can adopt, so that effectively the arbitration can be concluded. And as Lord Mustil has said, this arbitration, the entire arbitration is like a relay race where the baton is first taken by the institution or the court when appointing the arbitrator, then handing over to the arbitrator, and after again giving back to the court for enforcement. So if the relay race has to go perfectly well, then all the three elements has to perform in tandem, or it should dance in the same tune. And as far as multiple institutions are concerned, I think for a country like India or for a country like Malaysia, one institution in Kuala Lumpur or one institution in New Delhi will not help, because the parties are staying in different locations. And either these institutions should provide at least an online hub in all those districts or centers, where the parties can, maybe the arbitral tribunal can be in the main center, but the parties can either represent through the online centers or online clinics, where they can come with a lawyer and they can directly connect. Because you can't expect the clients to make arrangements for an online system where they can give evidence without the securities of interference or of course, the Seoul Convention has clearly mentioned as to what are the precautions that you need to take when you are doing online evidence, because you are only seeing the person in the limited scope of the camera. So how the 360-degree angle cameras can be operated by the arbitrator or by the institution to foresee that there is no interference of the witness. All these things cannot be done by a law firm or by a arbitration client. It has to be done by the institution, so that if it is not possible for us to establish centers all over the country, at least there should be centers or small places where the parties can come and connect with the main center to do the arbitration hybrid in the most secured manner. So I don't think that it is possible, like Singapore, to have one center and manage the entire country. But we need to have multiple centers, or a main center having multiple branches in different parts of the country.
Thank you very much. A little fun fact from something perhaps you should know. Mr. Anil is born in Malaysia. was born in Malaysia. He's got relatives in Petaling Jaya, Batu Pahat, Johor Bahru. I think he's got more relatives here than in India. But despite that, he says we have to have more institutions in India. Tan Sri Cecil, is the Malaysian executive doing enough to support the Malaysian arbitration landscape? Should there be a setting up of an equivalent study committee or expert committee like what is done in India, in China, in several other jurisdictions when we're looking at holistic changes to their landscape?
I think the Malaysian executive has been supportive of arbitration in two aspects. I think firstly, when the KLRCA was in its old premises in Jalan Konley, and I remember when we approached the Malaysian government that we needed better premises, we were given this present premises by the then Minister of Law. And that was supportive of arbitration. The second area in which I think the government has been supportive is this. When the Bar Council and other stakeholders made representations that the 1950 Arbitration Act was obsolete, we had, for the very first time, I think, cooperation between the Attorney General's chambers, the Bar Council, and other stakeholders, which resulted in our 2005 Act. So that's it. Now, I think it would be helpful if we had a commission set up to look at whether our arbitration landscape and Act needs to be amended. For instance, at the moment in the United Kingdom, there is a commission sitting looking at their 1996 Act. And so it would be useful if we have that commission set up in collaboration with the Attorney General's chambers, so that if there is a need to amend the Arbitration Act or the mediation, or enact a mediation act, or even look at the CEPA Act as such, and it could be done quickly. So I think in respect of that, we probably need more government assistance as such. And I think what government should realize is this, that with investment coming into the country, there will be disputes, and therefore arbitration is an important sector, and it shouldn't be put on a back burner as such.
Thank you. Thank you. Thank you so much. I move now very quickly to the role of the courts. We've heard enough about minimum intervention. We've heard how important it is to inculcate that culture. And I think the courts are listening. They are not just only listening, they are practicing it. But I think we truly, as a Fireside Chat, need to find out what happened in India in the stamping case. And this bit I can share with you. When I was in India back in December, I was in a panel with Justice Roy. And that's where in the NN Global case against Indo Unique, where in a nutshell, if I can put it this way, the fact that the arbitration agreement, the underlying contract itself was not stamped, was reason to not recognize the arbitration award, if that's correctly the way I can just sum it up. Because the contract itself was not stamped, therefore the court itself would not support and recognize the arbitration award. Justice Roy, who sat in the Supreme Court, disagreed with it, was the sole dissenter in a panel of 5. And in India, in the ICC arbitration week day, I sat with him and he was asked, why did he dissent? And his answer was, well, when I left home this morning, my daughter said, remember Dad, KISS. And he was trying to remember what KISS meant. And we were trying to guess what KISS is. And I'm not sure how many of you think KISS is keep it short and simple. Keep it short. Who thinks it's keep it short and simple? Hands up. All right. Who thinks it's keep it short and sweet? None of you? Oh, some of you. Thank you. Justice Roy said his daughter told him, keep it short and keep it short, stupid. So that was his daughter's advice, and that was his answer to the question as to why did he dissent. Now, that decision was quickly reviewed by the Supreme Court of India, and Justice Surya Kant was in that panel. Let's find out from him, and I hope he's not giving us the same answer as KIS as Justice Surya Kant. What happened?
No, well, here I need not to be hesitant in saying anything because the judgment is already there and is already pronounced it. Well, the slide, very briefly, I'm pointing out the legislative history that how and judicial history of that how it happened. That was in Anand Global 1 matter, where somehow or the other, in fact, there have been two parallel views in Supreme Court of India. It was only with regard to the interplay between two parliamentary central legislations, as you call, the Stamp Act on one hand and the Arbitration Act on the other. Dealing in isolation or singularly in one legislation, of course, any court would say that, all right, Stamp Act is one of the measures to collect revenue, and therefore there is nothing wrong. The Constitution permit to enact such a law, and stamping of the documents is a very well universally known mode of legitimacy of the documents, and therefore the courts would recognize it. But then ultimately the conflict or the gray area that arose for consideration was as to how to deal with such agreements which contain the arbitration clause also. Now, in such a case where if it is not stamped, then are you going to wait till the stamping part is adjudicated by a quasi-judicial authority under the Stamp Act, and then only such an agreement will become enforceable as far as arbitration is concerned, or the arbitration issue can go parallel and independent to the whatever the consequence under the Stamp Act. So Anand Global 1 was the one judgment where the three-judge bench of the Supreme Court ruled that the non-payment of stamp duty on the substantive commercial contract will not render the arbitration agreement contained in the contract unenforceable. So that was one, I would say, progressive view taken by initially a three-judge bench. But then somehow the other, some observations made in another three-judge bench which has nothing to do with the stamping of the arbitration agreement. There an old judgment of 2011 that Garwale Wall's judgment was referred to, and three-judge bench judgment was misconstrued as if it has taken a view contrary to Anand Global 1, that Vidya Drolia's matter, and this is how the a conflict was perceived between three-judge bench judgments, which frankly speaking actually it was not there, because Anand Drolia never dealt with that issue. Those were two independent kind of issue. But eventually this led to the reference to a larger bench of 5 judges, as we call the Constitution bench. And as Honourable the judge has pointed out, in the 5 judge bench, there was a difference of opinion. Justice Rishikesh Roy and Justice C.T. Ravi Kumar on one side, on 2 judges, and the 3 judges led by Justice Joseph, they took the view that because Stamp Act is also a legislative, parliamentary legislative, and there is nothing to reconcile between the two statutes, and the interplay will be that an agreement containing the arbitration clause must also necessarily be stamped. Then only you can look into the validity or enforceability or invoking of an arbitration clause. So this is how 3-2 the majority view prevailed, and the 5 judge majority view was taken that Stamp Act will prevail on the Arbitration Act. But as I would frankly say, we were extremely unhappy the way because we have been, as a judicial policy, the Indian Supreme Court has been promoting the arbitration law, And therefore, we felt a bit apprehensive that in the international business community, it will have very chilling effect as far as the arbitration growth in India is concerned, and the people will be very much discouraged. And we were simply wondering that what will happen in a case where the arbitration agreement is executed through emails or through a lot of modern technology, where there are no formal documentations which are require stamping, and at the same time those arbitration agreements, say business transactions dealing with such kind of movable or immovable properties which may require stamping, but at the same time those documents are not formally executed in India. So what will happen with those cases? So all these issues were arising in our mind, and as you will say, this is one of the law which in the quickest time, and we had allowed a wrong principle of law to survive only for the shortest duration, I must say, in India. Then immediately we constituted the 7-judge bench, and we all were unanimous about it, that the stamping or the of an arbitration agreement has nothing to do whether the agreement requires stamping or not. We said it's also a part of arbitration dispute, and it is for the arbitrator. Therefore, we wanted to maintain and respect the autonomy of the arbitrator, the autonomy and independence of the arbitration clause also. And we said that nothing to be done by the courts or the quasi-judicial formed under the Stamp Act, and even the question whether a document requires stamping or not, and if requires, at what stage it will require, we leave everything to the absolute discretion jurisdiction of the arbitrator. And that is what the law has evolved, and we don't see that there is any violation of any Stamp Act. It's a question of interplay between the two statutes. We have fully respected the Stamp Act. We have not exempted the documents only because it contains an arbitration clause that it won't require stamping. Yes, it will require stamping, but at an appropriate stage, without creating any impediment, without delaying the arbitration process pursuant to such agreement. That's what ultimately we have summed up in that.
Just before you respond, Tan Sri, from the Malaysian perspective, Mr. Anil, what was your reaction when you heard about the decision of the review court?
It was such a relief in the sense we were so much worried because so much of arbitrations that were going on had to be stopped.
Thank you. Tan Sri Cecil?
This situation will never arise in Malaysia. For instance, if an advocate takes the point in an arbitration that the agreement is not stamped, a competent arbitrator will then ask the other side to give an undertaking to have the agreement stamped. And if it happens in court, I think the judge will ask them to go downstairs and get the agreement stamped. Furthermore, an advocate in Malaysia who takes such an unmeritorious point will be up before the Etiquettes Committee of the Bar Council, because you are not supposed to take the point that an agreement is not stamped as such. So I must say that I am really astounded that this sort of argument was taken in India, and that it had to go all the way to a 7-man bench to correct it. So, Judge and Mr. Xavier, if India is to be a seat of arbitration, I think you cannot allow decisions of this nature to be handed down by your courts. But I'm very happy to see that on the 13th of December, it was immediately corrected, and that augurs well for the speed at which your Indian judiciary reacted to this. Because I would have thought if it wasn't uncorrected, hundreds of arbitrations could be set aside because the agreement was not stamped.
That was exactly Mr. Anil's reaction. He said so many arbitrations had to be put on hold, and therefore, but what Justice Surya Kant has explained to us, the Indian judiciary rose to the problem, address it speedily and most efficiently. I was going to go and ask about another question, but really in the interest of time, I'm going to come to the final sector. And here I would like to take just a quick show of hands from the audience for the last question about the future and about our young arbitrators. Can I just find out how many of you in the room are under 45? Hands up, under 45. There you are. I don't want to ask about the rest where you are. Right, under 45. Can I start with you, Mr. Anil? What would you advise to these under 45 on a Tuesday afternoon who are here, eager, interested, not just about India and about Malaysia, but specifically about arbitration, specifically even more about arbitration and arbitrators? What's their future? Not just about gender, but about geographical. How am I going to meet up, challenge to a white, male, pale, and quite stale arbitrator? What's your advice to them, please, Mr. Anil?
No, as far as India is concerned, there is a huge hope for young arbitrators in the sense, see, most of the non-banking financial institutions or banks, see, they have huge number of disputes. If you take a single non-banking financial institution, they will have an average 2,000 arbitration disputes every month. So that means about 24,000 arbitrations every year if you take one single non-banking financial company, and we have hundreds of it. And there is a restriction in Schedule 5 of the Arbitration Act under Schedule 5 that an arbitrator cannot take more than 3 cases of a particular company in a 3-year span. So that means the earlier regime where hundreds of arbitrations or thousands of arbitrations were conducted by a single arbitrator of a particular company cannot now do arbitrations of that same company more than 3 times. So that means in a country like India, we need, it's not thousands, we need lakhs of arbitrators, and we cannot go back to the senior arbitrators to do that. We need young, efficient arbitrators to handle it. So now we have taken an initiative to go to law schools and get the final year law students also to become arbitrators, because they are graduates, because after 3 years they are supposed to be graduates. So we are going to the final year students and we are establishing arbitral centers in every law college so that the law colleges itself becomes dispute resolution centers. So along with learning law, they can also participate in justice delivery, and they can become arbitrators we have made an expedited arbitration rules for that, so that those arbitrations can be done without oral evidence, but documentary arbitrations. And it will be mandatorily sent to a scrutinizing committee, which will oversee the award, and then it will be published. So the hand-holding of young arbitrators, we are very serious about, and we are taking a lot of efforts in promoting young arbitrators into the field of arbitration.
Oh, wow, what exciting time. I hope those who are listening and following us from India, you are in such a privileged position, such interesting times with this mentorship program, and it's really happening on the ground as you speak. I mean, the volume of work that's going to come. Tan Sri Cecil, can we say the same to our young hopefuls here?
No, what I would say to those young who want to become aspiring arbitrators is this: there are a whole series of organizations which cater for young arbitrators. For instance, there is young ICA, young IBA, and other organizations. So you should join these organizations. But I think more important, you need to sit for the various exams that are conducted by CIARB, MIARB as such, and gain arbitration knowledge as such. And the other thing that one should do is perhaps attach yourselves to firms which do arbitration, so that you can follow the seniors who are doing arbitration, and in the process learn. And I think the other thing to do is to attend seminars like this, so that you can pick up 1 or 2 useful things. But I think what is also important is that the Bar Council has a role to play in that it should set up courses in arbitration for young lawyers to learn the various aspects of arbitration.
Tan Sri Cecil's last comments was about the Bar Council setting up courses and programs for the young arbitrators. I was just hoping that Tan Sri Cecil is going to throw an offer to the ground and say, my next international investment arbitration, who would like to come along? Perhaps that's something Tan Sri might like to consider. Yes.
Well, I do always take one of the young lawyers from my office if I'm presiding arbitrator to sit as secretary.
There you are. Thank you. Thank you, Tan Sri. To you, my learned brother, to our favorite guest here, Justice Surya Kant, having had the experience from the bar, serving the government as the Advocate General, and now at the apex court of a cradle nation, India, on its bench, what would your advice be to the young hopefuls who would like to think arbitration perhaps is the most appropriate way to resolve our disputes, as advised by our Mahatma Gandhi, that conflicts are unavoidable. Let's find a peaceful way to resolve it, and arbitration perhaps is the most peaceful way. What's your advice to them, please?
Thank you very much. First of all, I must say that I have a great weakness for the young and future generation of the legal luminaries. I'm extremely positive and very optimistic about the young people coming in legal profession, irrespective of the jurisdiction, whether it's India, Malaysia, or any other jurisdiction. I'm very, very confident about the quality of product now coming in the market. So because of that, I'm extremely confident about the outcome also which they are going to deliver. But as you know that with the so much progress in all over the world and with the advancement of technology and everything, the geographical jurisdictions in due course of time are indeed becoming meaningless. So therefore, I will see among the young people sitting here, I foresee you the future international arbitrators. And for that being, first my advice will be that you must be well conversant about the rules and regulations and about the legal regimes of various jurisdictions. You need to update yourself about that. You should be where everything should be on fingertips, whether if I ask you something about Singapore or if I ask you something about European, you must be fully conversant about that. That's one part. Second part, as I said earlier also when I was interacting with you, the competence and integrity of an arbitrator is extremely important. So I will request all of you to concentrate on that, and you need to be you need to really inculcate and you cultivate in yourself that culture that you are acknowledged irrespective of your age and experience on your side, that you are known to be a very well conversant, a person of a proven integrity in terms of your arbitrator's quality. The third thing which you need to be is that you need to be completely neutral. You see, what is an arbitrator? An arbitrator is only a private judge of a private court. So all the abilities, the qualities, the requirements of a judge must be reflected in an arbitrator also. And neutrality is along with impartiality and independence is also a very, very important factor. Therefore, I will request you to inculcate that culture in yourself and try to be neutral. Extremely important for a litigating party when they come and trust you as a judge is your ethical standards. So that's also where you need to make a lot of investment. ethically we must be very sound. Our conduct, our behavior, our observations must be always ethically sound, neutral, and we must represent an impartial personality where as I said, the business community can have trust and faith, and they can really depend on you, and they can have full faith for the purpose of the adjudication. In addition, of course, you need to yourself associate with good qualitative institutions, and initially, in the initial stage, I would say that you should not think of a small arbitration or a big arbitration, associate arbitrator or the independent arbitrator. Your endeavor should be to enter into the field of arbitration, and whatever opportunity you get, you show your worth, and you display your ability as an ideal arbitrator. Updating yourself in the law of your own jurisdiction and other jurisdictions is extremely important, and your availability, your online accessibility, and your approach to the future dynamism of arbitration, I think that will be extremely important. Arbitration is one field where you cannot go by convention principles. Sometimes you have to come out with certain solutions out of a kind of hat, and therefore you should be very innovative also. That's again a very important factor in your personality. That's what I think that the young people should try to mold themselves to be an ideal arbitrators.
Thank you very much. Such gems, and I hope you take heart, ladies and gentlemen. Anil?
I thought having a fireside chat, and since all the young, most of the young lawyers are here, from the side of India, we should give you a gift. So our expedited arbitration, which I said earlier, is, see, as per our law, we can have international arbitrators or foreign arbitrators to arbitrate our disputes. So the expedited arbitration, which I said earlier about going to law colleges and getting the youngsters to arbitrate, it is open to lawyers, all of you sitting here. You need to catch hold of Iram Majid sitting here, who's the executive director of APCAM. She's in charge of that project. You get her immediately after this and get yourself as arbitrator and become arbitrators in India.
Wow, thank you so much. What a way to end. Honourable judges, ladies and gentlemen, it's 6:37 in the evening. It is with a lot of humility that I thank you for staying the course with us. And please join me in showing our appreciation to these eminent speakers, Justice Surya, Kant, Cecil, and Mr. Anil Xavier, who have more than generously shared in their experience and skill. Thank you.
Thank you to our panel of speakers for this insightful session. May I kindly request the speakers who are here with us to remain on stage. And we would now like to invite Datuk Sundra Rajoo to come up on stage to present the tokens of appreciation to our speakers.
Yes, please.